Hi, my name is May, and my group members are Stacy, Veronica, and Jessica. My group has chosen Sony Corporation for our group presentation. In Stacy's presentation, she brought up a hypothetical scenario involving a dispute over intellectual property infringement. I am on the litigation team currently assigned to the discovery portion of the case. I will be going over a deposition subpoena of Twitch's person most knowledgeable pertaining to the responsibilities of the former Twitch employees in the underlying action. Litigation can be very complex and time-consuming, so let's first dive into the life cycle of a civil case. It starts with the filing of a summons and complaint by the plaintiff, outlining the allegations and details of the event that led to the dispute. The complaint is then personally served on the defendant by a messenger. From there, the defendant then must file an answer admitting or denying the allegations of the complaint. Then the case moves into discovery, in which both parties will begin to gather evidence and new information to strengthen their argument of the case. This is generally the longest part of the civil litigation process. It begins after an answer to a complaint is filed and goes until shortly before the trial. During this process, the parties may file motions to ask the court to rule or act on certain issues of the case. Some examples are motion to continue trial, motion to dismiss, and motion for summary judgment. Alternatively, the parties can participate in mediations to settle the case without having to go to trial. Keep in mind that trials can be very expensive, therefore most civil cases are settled right before trial. If no settlements are reached, the parties then move into trial, where both parties will present their arguments to a judge and or a jury. The judge will then issue a verdict of the case. If a party does not agree with the ruling can be appealed to an appellate court in the post-trial process.
Discovery process, as it is the most time-intensive and expensive stage of the litigation process. For the most part, discovery takes place outside of the courtroom, with parties exchanging written information and cross-examination through deposition. Think of discovery as obtaining and disclosing the evidence of each side of a case so that the parties can decide what their best options are, move forward with a trial, or negotiate an early settlement. Generally, a party can obtain information that pertains to any issue in the case. There are limitations as to what information is discoverable. Certain types of information are generally protected, including information which is privileged, such as attorney-client communications, trade secrets, and conversation between spouses, and the work product of the opposing party and his attorney. There are several discovery tools available to the parties in litigation that can be divided into two broad categories: written discoveries and depositions. Written interrogatories are consisted of three main types of documents: interrogatories, requests for admissions, and requests for production of documents. The written questions and requests are propounded by either the plaintiff attorney or defense attorney to the opposing side of the case. The opposing party is then required to answer the propounded questions and produce documents under oath that the answers given are true. A deposition is an oral testimony given by a witness under oath in front of a court reporter. The primary purpose is to find out what the witness knows and discover information about a certain situation or an event relating to the dispute. The deposition transcript may be used as evidence at trial. Under Federal Rules of Civil Procedure Rule 30, a party may, by oral questions, depose any person, including a party. The deponent's attendance may be compelled by a subpoena. For example, a defense attorney can depose the plaintiff, who is a party to the case, and the plaintiff's friend, who is a third party or a non-party to the case. The general rule is that a party who wants to depose a person by oral question must give reasonable written notice to every other party in the case. The notice of deposition must state the time and place of the deposition. If the name of the deponent is unknown, the notice must provide a general description sufficient to identify the person or particular class to which the person belongs. The parties may stipulate to have a deposition taken telephonically via Zoom or by any other remote means. For the purposes of this project, this deposition will be taken in person at Aiken Welch, which is a court reporter's office in San Francisco. A court reporter is a trained professional who transcribes verbatim records of legal proceedings using a stenograph keyboard. To the right side, here is a picture of what a stenograph keyboard looks like. Before the deposition begins, the court reporter will swear in the witness to make the deposition official and legal, similar to an oath administered by a notary public. Once the witness is under oath, the court reporter will state his or her name, the business address, the time, date, and address of the deposition, the name of the witness, and identify the people at the deposition. For example, the start of a deposition can go something like this. Today is Monday, March 1st, 2021. The time is approximately 8:31 a.m. The location is 180 Montgomery Street, San Francisco, California, 94104. My name is Sarah Wells, a court reporter of Aiken Welch. This is case number CIV 12323234 filed in the United States District Court, Northern District of California, entitled Twitch Interactive Incorporated versus Sony Interaction Entertainment. The deponent is Sam Smith. The video deposition is requested by John Spencer, attorney for the defense. Counsel and all people present, will you please identify yourself for the record? So when after a deposition is completed, the court reporter will finalize the deposition transcript and send a copy to the parties involved so that they can review the transcript and have it revised if necessary. In my deposition subpoena, I have chosen to notice the deposition of Twitch's person most knowledgeable via subpoena under the Federal Rule of Civil Procedure, Rule 30b-6. It permits a party to notice or subpoena the deposition of a public or private corporation, and it must describe with reasonable particularity the matters for examination. In response, the named organization must designate one or more officers, directors, or designate other person who consent to testify on its behalf, and it may set out the matters on which each person designated will testify. The person produced as the PMK or PMQ may be an officer or an office worker, but it is the responsibility of the notice party to designate the correct person. Multiple persons may be produced per topic or category stated in the notice of deposition. In other words, Sony cannot select the identity of the person to testify. We can only provide a list of topics in which Twitch will designate a person or people who will testify as to each category. A subpoena is a written order issued by a court to compel a named individual to give oral testimony on a specific date or to produce document by a specific time. It can be used to command a person to appear at a deposition to give oral testimony or to produce documents designated in the document request. The rule states that a subpoena must state the court that from which it issued. In other words, the name of the court where the underlying action is pending. In our case, the action is pending in the United States District Court, Northern District of California. Second, the subpoena must state the title of the action and its civil action matter. Here, the action of the case is Twitch Interactive Inc. versus Sony Interaction Entertainment Inc. The civil action number is located on the right-hand side at CIV 1232 3234 324. Third, it must command each person to whom it is directed to do the following at a specific time and place: to attend and testify, to produce designated documents of electronically stored information or tangible things in that person's possession, custody, or control. In my subpoena, Twitch Interactive Inc. persons most knowledgeable is commanded to appear on March 31st, 2021 at 9 a.m. at Aiken Welch. In addition, the PMK is also commanded to produce documents listed in the attachment 3 in the following slide. In this attachment 3, the definitions and the requested materials are clearly defined so that the notice party have a full understanding of what will be asked at the deposition. It also includes Twitch's obligation to produce documents as listed in the following categories. Lastly, a proper subpoena must include a certificate of service, as all discovery documents are required to be served on the parties involved. For cases pending in state courts, this is known as a proof of service. Here, the documents will be served via CMECF, a federal judiciary case management system.